All right. Hello, everyone. Hello. Good morning. Good afternoon. We're going a little bit early this morning. It's 11:30 here on the East Coast, but welcome to another edition of Law Roundup for May 9th, 2022. Brad, why don't you take us away?
Sure. So this week we've got a couple of some simple issues which we're going to kind of discuss and dispose with, and then we have some more in-depth legal issues we'll talk about. So first, let's move to Pennsylvania, where a fire chief and his wife, both volunteers, his wife was the treasurer, is charged with stealing I shouldn't say only, but $2,700. When you watch the news release, you see that they're accused of stealing funds for their personal purchases. But as I looked, like one of them was a fuel pump. But when you look at this, they are things that could be easily disguised as, department purchases. So again, we make no comment whether there's guilt, innocence, etc. This is just an allegation. But I will say that one of the things that is common that I see in methods of how people try to steal is that people buy things for their own personal use, but they are, if you don't look too hard at the receipt or you don't verify whether the item was actually received, it could look like it was a fire department's purchase. So maybe that's what happened. We don't know how they got caught or accused. All we know is that they're charged.
Yeah, let me just point out. I mean, we know, and it's not every week, but it seems like we don't go more than a week or so, 2 weeks, without some sort of theft case, particularly in the volunteer service. And I know I was kind of caught by surprise. I've written about this a little bit, but the prevalence of females involved in the theft. And again, we don't know anything about this particular case, but there's an excess. If you look statistically at it, there's an excess, particularly given the percentage of women in the fire service. Very often they're the treasurer. And while you were talking, I just did a quick data analysis, and I've got 54 cases of a husband and wife team stealing in the volunteer fire service. So it's more than just an anomaly here. And I'd have to drill down into the data, but my sense is that most of them follow the same pattern where the husband is the chief, the wife is the treasurer. And so certainly it's something for fire companies to kind of think about. It is a very common fact pattern. And again, I know sometimes allegations are made and they're false. Like they're out to get the chief, they're mad with the decision the chief made, and so they're going to make these false allegations as well. So those happen as well. So, but again, I've got in my database, I've got 54 documented cases of husband and wife teams stealing from volunteer companies.
Yeah, and I'll tell you, I get asked all the time, is it a conflict of interest? And conflict, very quickly, there's two types of conflicts. Those provided by written law, statute, and at least in New York, it's not a statutory conflict. And then there's situational conflicts, and it's not even a situational conflict. But I always follow up when I'm asked that question, and I'm asked that question constantly. I said, but is it really a good idea? It's not a good idea because it's a little bit of fox and hen house. So I try to encourage people not to, have, whether it's a commissioner and treasurer, chief and treasurer, director and treasurer, you shouldn't be related to the treasurer at all. It shouldn't be related to employees. We just have to have better systems in place. But you're right, this is not uncommon. Yeah. And I don't know what the issue is with women stealing because
I can tell you. I can tell you, and one of the folks, I think I did it a while ago, but I had a gal on that specializes in pink. She calls it pink collar theft. And she said they're equal. The thing is, they're equally likely, male and female are equally likely to steal. And that's the thing that escapes us, that we assume, maybe it's a mommy complex, whatever the issue is, we assume that women are less likely to steal, and they're not. And so we give them a free pass, and we don't put the same systems that we need to have for everyone in place, because we make this assumption that they're less likely to steal. And the reality is they're not. Now, they're less likely to commit an armed robbery. Okay, they're more likely to embezzle and engage in that. But in terms of their willingness or proclivity to steal, it's just about the same. They're not more likely, they're not less likely. It's just about the same. But our sense is that that's not the case. So that's where we're vulnerable.
And I got to tell you, I teach, as you know, I teach like a 2.5 hour course on how people steal, right? Because I figure if I could teach you how they steal, you'll understand why you have to take protections. And I always end up apologizing because I go through the first 10 or 15 cases of different types of theft, and it's always women. And I keep saying this woman, this woman, this woman. I'm like, I'm not making this up. I'm just telling you, for some reason, it's mostly women. I have a theory, and then we'll move off. But my theory is bad times make good people do bad things. And maybe more bad things happen to women in the fire service than men, that they need to, access the funds. I don't know. Clearly, it's not universal, but you're right. It's a higher incidence considering the number of women. But either way, we got to stop this theft. It's a black eye, and we're not saying that he's guilty or not. But generally speaking, it's a black eye.
Yeah, I'll throw out a shout out for Kelly Paxton. Kelly is she's a forensic examiner, and she's made it her mission in life to really look at some of the pink collar theft issues, not just in the fire service. She happened to reach out to me asking about what was going on in the fire service, but she covers all sorts of industries, and it's a very common problem because of the sort of free pass that we tend to give women. That you're gonna have systems. That's the bottom line. Is we've been how many out of the weeks that we've been doing this, months that we've been doing this, how often have we said that you have to have a system that's going to manage those risks? And very often we don't.
We operate on a system of trust, and nobody would ever steal from us, except when the person steals from us, it's always the person we trusted. So okay, I'm going to do another quick one before we get into some more substantive ones. Here, Jamaica, and this is not Jamaica Queen.
I added this one. I just thought it was kind of funny, but
well, it relates back to one we did in another retaliation claim. But here, basically, in Jamaica, the country, right? Firefighter, he's staging a one-man protest over having to go back to 8-hour shifts that they've been on 24-hour shifts. And going back to 8, he argues is burdensome. I look at this, okay, what if this happened in the States? Is it a free speech issue? My first comment, and so he's protesting. He's got his shirt off in a picture. He has 24 written on him that says, 24-hour shifts. And look, in fairness, he's right as to the detriment of 8-hour shifts. You remember a couple of weeks ago, we had a city allegedly retaliating against its firefighters by moving them to 8-hour shifts, which are a horrible shift. No fire department would ever do it as a good practice, right? But here I looked at this and said, okay, he's suspended. If he sued here in the States, would it be a First Amendment right? And my conclusion is this is totally an employee-employer issue, not a matter of public concern. It may tangentially involve some tax monies and maybe involve some public safety issues, but really he would be denied even a First Amendment right. I don't know if you disagree, but
yeah, no, I agree, and even on the other count as well, because it's it's going to be a matter of public concern, and you have to do it as a private citizen, and he's on duty in his turnout gear. So the only hope. Right. The only hope he would have would be some sort of collective bargaining protection, but I doubt that that's going to attach because he's on duty. So, at any rate, I thought it was interesting, and I do recall that. I think it was East Chicago. Was it East Chicago? But we had a fire department where they were put on 8-hour shifts to punish them. And here, I guess in Jamaica, that's their normal shift, which I think is, again, it's terrible. There's no, you work 8 and then you're off for 24 and you kind of rotate around the clock. So you do a day shift and a evening shift and then Jamaica. Night shift.
Right? I mean, we
Yeah.
don't know Jamaica, look, maybe everybody lives right there. Who knows? Maybe 8 hours isn't a big deal, but
there's no day off. I mean, depending on how many, if you only work 40 hours a week, that's one thing. But if you work 56 hours a week,
yeah,
you know,
it's horrible.
eight times 7 comes out to 56. So, you know,
That's
you don't have a
horrible.
day off. You don't have a day off. So,
right. Okay. This one, I think you're better suited, no pun intended, to handle. But the Maine drowning lawsuit, I can give you some quick facts. But this is one of the things I think Rhode Island. But you're very familiar with these duty to act states. I don't know whether you want to do the facts or do you want me to do them. But
no, go ahead and do the facts. And you know, I mean, it's a. I mean, if you want to, you know, it was in Portland, Maine, and we had someone who he was causing a disturbance. The police were requested. He fled the scene.
Potentially psychotic.
Yeah, he's got some issues. There was some unusual behaviors. You can get all that from the you know, from the ruling here, but basically he jumped into the ocean waters. Portland, Maine has a lot of bay and inlet areas, and there's several bridges and so on. But bottom line is, he jumped into the water, and I'm not sure the time frame, how long, but you know, they were basically watching him. The water was not that deep, and but he was gradually becoming hypothermic. And at least, again, these are the allegations, and I find some allegations in a case like this to be convenient for the plaintiff to make, and maybe not representative of everything that happened, although there was a body cam video to document some of the allegations. But they were apparently trying to get to him with a marine vessel. There were other people on shore that were trying to figure out how to get to him, and they were calling to him, trying to get him to come out of the water. And the bottom line is, he drowned. And there was some question about him possibly being violent and people not wanting to go in the water to wrestle with him in the water, and the muddy tidal flats and other, you know, logistical problems that, if you're familiar with Portland, you kind of get the sense that, you know, it wasn't just you know, just swim out and grab this guy. That, you know, there's a lot going on there, and risk, you know. But I guess at the heart of the issue was an unfortunate comment that one of the is attributed to one of the firefighters, and I'm just looking through the post here to try to get you know, one of the fire
out of the water.
Yeah, one of the firefighters says, "I will kick his ass if he comes out of the water," which, you know, the family is claiming now, if the citizen heard it, the person who's in the water heard it, would tend to make them want to stay in the water and then succumb to the hypothermia. So the case was brought under a civil rights violation, under, you know, those of you familiar, the legal eagles out there will recognize 42 USC 1983, which is a, you know, civil rights type of action. And they're claiming that his right to life was violated. His right to, you know, right to not have his life taken without due process was the civil right in question. And that the making of the statement and their overall handling of the case, and again, I want to get the allegations right, but shocked the conscience, showed deliberate indifference toward the Mr. Cohen's right to live.
If true, right? If that's true, that's what they've at least alleged, so the case goes forward.
Right. So the bottom line is that the case was dismissed against most of the people that was sued, the police officers, and I think it's going to continue now against this particular one firefighter, but also against the city. So I don't know, you know, you take out your crystal ball. Where do you see this one?
Oh, I think they're getting, well, look, they're going to trial, is, you know, it's my phrase, but there are questions of fact. Now, that said, I've won cases at a motion for summary judgment, a later stage, where you have a video of the entire incident in question, and they may have a video of the entire incident in question. And based on that documentary evidence, the court can skip a trial and say, look, there's no question with what I see here and what happened. And as long as that answers the questions of fact, the judge could rule. And my crystal ball is the fire department wins. I'm surprised, though, a little other ways is that they, look, it's allegations. What they're ultimately going to presumably come up with is a policy that says we don't have a dive team, they don't have a rescue team, they don't have a cold water team. I don't know that to be true or not. And that's not something we do. My question would be, did they activate one, right? And I didn't see any of that here. Did they at least arrange for somebody else to do the rescue, or are they just standing watching? If they didn't arrange for somebody else to do the rescue, then I fear for their, the bad result, because why wouldn't you? You can't stand there and say, well, we don't do this type of rescue, so we're not going to do it. And even where they say, well, somebody's dangerous, right? And so we didn't go get him. That's fine, but you set up for the rescue until he's no longer dangerous. So if he then went down, right, and you could then make the rescue, you should have been in the position. So I don't know, too many facts. I don't know.
Yeah.
Who knows?
Yeah, it's a difficult fact pattern, and I think we got to kind of separate a couple of things. One is, did the police and fire department, did the city of Portland respond appropriately? Okay, in terms of the resources and I believe they had a Marine unit trying to get to the person from the water side, and they had some resources on the side. And did they have, I'm sure they had exposure suits and survival suits and all that trying to get to them. But were they taking care of that? But then I think the issue here is the comment that was made. Could the comment have somehow led the victim to believe that it was not safe for the victim to get out of the water?
If he heard, which is hard to imagine.
And again, there's a question if he heard. And I think, the lesson, whether the city wins, whether the firefighter who's being sued wins or loses, the lesson here is just don't make stupid comments. Don't make stupid comments. And
well, it's no different than getting on Facebook or social media after a fire and say, "Hey, great fire."
Yeah.
It's not. Look, of course,
I'm guilty of that. So.
But look, of course, that firefighter would go in to make a rescue if they were permitted. But that was the other thing, is what I didn't see in here, because it would have been my defense if I was a fire department, if true, was it ain't our scene yet. He's still a criminal. He's still violent, right? Possibly. And the police, it's their scene, and we don't handle violent patients until the police, tell us we can. So even though that doesn't help the city, it helps the firefighter to say, I wasn't given the go ahead. It's their scene. So again, so much we don't know.
Yeah, and this for folks who find this fact pattern may be troubling in their jurisdiction as well. There was a similar case out in Alameda, California, several years ago, where the fire department had eliminated water rescues. Basically, they gotten rid of their boats. They had gotten rid of their surface water rescue team for funding reasons. And then they basically watched the gentleman commit suicide, drown.
Was that the First Amendment case, or am I thinking of Ohio or a case? There was a First Amendment.
Oh yeah, they're right. No, that's a good one. There was an Ohio ice diving case.
And they watched the person go under.
Yeah. And
the captain shows up at the city council saying, "You killed him," and we were forced to watch him go under.
Right.
Great First Amendment.
That was a First Amendment case. Yeah. So. You start to see, as you start to look at these cases, you start to see some similarities. And I always say, when we start to see several cases in a row, or not necessarily time-wise in a row, we start to see several cases with similar fact patterns. It's an indication, just like a line of duty death, that, hey, you know what, maybe there's something here. Maybe we need to focus a little bit of attention, some forethought on how are we going to prevent this from happening in our department.
Right.
So.
Okay, this is a great and very important issue. We're going to go to Idaho, but this is a big deal, I think, right across the nation. So maybe we should have started with this, but this is a big deal. So in Idaho, Idaho has a cancer presumption law. If you get cancer within X years of no longer being a firefighter, or while you're a firefighter, there is a presumption for certain diseases, in this case, including leukemia. But there is a statutory, a law-given presumption that your cancer was caused by firefighting. And here the city fought somebody's presumption, and it's so important for everybody to understand. This case is great. I think it's not monumental, but it's getting to that level in this area. And I didn't know how high this court was.
It's a Supreme Court. It's the Idaho Supreme Court. I don't think they have an intermediary. Yeah, but I don't think they have an intermediary in Idaho. That you go right from trial court to the Supreme. That's what we have in Rhode Island. We don't have a.
And remember, in New York, Supreme Court's the lowest for whatever reason. So in Eggman, so the city challenges the firefighter's assertion that he's entitled to benefits because he got cancer from firefighting. And what I'm going to make this simple, but I want to read a couple of the lines as you pulled out in the blog. What the city says is, listen, we couldn't show, and the firefighter hasn't shown that he got cancer, he got leukemia as a result of firefighting. So since he can't show that that's why he got it, and since he couldn't come up with any other reason he would have gotten it, the city says we should win. That's exactly the opposite of what a presumption is. And I'm surprised. Look, maybe they had to try something. I think it's shitty anytime. Obviously, we're firefighters and lawyers, but anytime somebody tries to take away benefits like this. But, they look, and the court has two holdings. And first they say, look, leukemia is included. But more important is they correctly determined that the city failed to present, and this is a quote, substantial evidence to the contrary to rebut the presumption that the firefighter's cancer was caused by the occupation as firefighter. In other words, the city tried to say, we don't have to prove anything. All we have to prove is there could be some other cause. And that they didn't really get that far because they couldn't come up with any other cause. But even if they had come up with another possible cause, I don't think that rebuts the presumption. You better come up with pretty conclusive evidence to rebut a presumption. And so everyone knows rebutting a presumption means, look, the courts look first to you have cancer, and we're going to assume that if you have cancer while a firefighter or within the 5 or in some cases 10 years after being a firefighter, we're going to assume that's as a result of firefighting. To overcome a presumption is a big, hard test. And we see this we're going to see it soon in discrimination cases, harassment cases, but it is tough to overcome a presumption. And you don't do it in this case by simply saying, well, we couldn't come up with any reason you had it, and you couldn't come up with any other reason you had it, so we're going to assume it's not because of firefighting. It's a tough burden.
Yeah, I thought it was interesting too. The city made a couple different arguments that you got to kind of tease out. One of them is that they alleged that the statutory scheme here for the presumption was unconstitutional. And what they said was that the legislature did not have scientific data to support that cancer and leukemia was more likely in firefighters. So therefore that it was an irrational enactment and therefore it should fail. And the court dismissed that. They really didn't even entertain it on a level. But the bottom line is, if you think about this whole issue, now it's one close to my heart. I know we fought for it here in Rhode Island, that if you don't have a presumption, it's almost impossible to prove that one particular incident or one particular, fire or exposure or even exposures over the course of your career led to a certain cancer. So it's almost impossible without the presumption. It's almost impossible. And what the presumption does is it flips the script, and now the burden to disprove is on the municipality. And it almost says, without a presumption, how difficult it is to prove it, it's just as difficult to disprove it when the burden is now on the city. So interesting case. I think they came out nice, came out the right way. I really like the Idaho statute. I mean, it's not, ours is clean cut. If you have cancer and you're a firefighter, bingo, no further need to inquire. It's it's done, unless they can rebut it somehow. They have a lot of language that, and the reason why I like the way Idaho did it is because if you're facing a legislature that's very skeptical and may not want to side with you, there's a lot of things here that both protect the firefighters but also serve to protect the municipality, including you've got to have at least 5 years on the job. The cancer has to be diagnosed within 10 years of your retirement, and there's a few things. So you may want to take a look at that, Idaho. It's a good, if you're in a state where you're maybe lobbying, you may get some ideas that may in turn persuade some legislators who maybe were opposed to the legislation the way it was originally introduced. They may be willing to go for this kind of language.
Yeah, New York's volunteer, on the volunteer side, not the career, on the volunteer side is very much like this. The career side is more like yours. But let me make a big suggestion to everybody, career, volunteer alike. NIFERS, if you're filling out the NIFERS reports, and you all should be, NIFERS has a optional module for hazardous materials. Now, normally you would think it's only used in a hazmat, but I tell everybody, every time there's smoke or fire that you've been exposed to, you should be filling out the hazmat, and you check, I don't know, as to what's burning, I don't know. But at least now it puts you into a hazardous material, right, where you can say, well, at least on this date was some unknown burning, right? Like dumpster fires, house fires, who knows what's burning, but you can at least show a date of exposure. And I think universally that should help all of you. It may not be necessary, but I don't care. Do it for everybody so you could show you were at least exposed. I have seen a challenge where they said, yeah, but how many structure fires were you actually in the fire for, where you actually had been exposed? And that's really where the employers get to challenge you, saying, you were never even exposed to anything. Show us what date and show us what action. Oh, well, I was at this fire. Yeah, but you were the RIT team outside, or you were exterior, or it was defensive only, right? You bet. I think your chance of losing is not showing that you can get back to an incident. And not that I ever would, but if I was on the employer side, that's what I'd be doing, saying, show us. Now, on the employee side, I'd be saying, well, you didn't give us a way to document it. But for everybody's sake, use the NIFERS hazmat module and just check unknown what the heck I was exposed to. Every time there's a fire, every 100 incidents in the NIFERS codes, you should be filling out the hazmat incident. Okay. Anything else on that, or we move to?
No, I think it's good. It's an interesting case, and again, I'd encourage folks to take a look at that statute, the Idaho statute, as a good model. If you've got a good one, like we have a good one, we wouldn't need it. New York has a good one for the career firefighters. But if you're in a state where you've been battling and the legislature's really pushing back against you, I think there's some language in that Idaho legislation that may be enough to convince maybe some legislators that are on the bubble to go in your favor.
Agreed. Okay, so let's go on to California, where we're just so used to being. Seems like California, New Haven, who knows? But this is an interesting lawsuit, more for the lawyers than the firefighters. So I'm going to try not to bother everybody, but I was so intrigued that I started doing some research on a theory I had in this case, because I'd get rid of this if I was the employer. I'd get rid of this immediately. So we're in California. A firefighter claims that he was, and I'm going to try to make this very easy. You give a long detail of the facts. I think I could do it somewhat easy. The firefighter works for agency number 1 in California. The firefighter, while employed at agency number 1, testifies against agency number 1, even so much as at grand jury, where they're moving for criminal indictments, and based on allegations of theft and a bunch of other improprieties. The firefighter is still employed there, no issue, but wants a job transfer to agency number 2 in California. But best I can tell, they're not, at least in your facts, they're not part of the same government entity. They look to be separate agencies. So that's what piqued my mind. You'll see in a minute to do some research. So he applies to go to a job for agency 2. He passes all of the tests, and in fact is then told, pending a background test, we're going to offer you offering you the job. Now, again, these are all allegations, right? We're not saying this is true. This is what's alleged. But he then doesn't get, he undergoes a background check apparently, and then doesn't get hired. And he had provided, I don't know why, but he provided all of his information on his being a whistleblower, which is very important statements. He provided all of that to his prospective employer and gave the whole background, explained everything. In any event, they don't hire him ultimately, despite the contingent job offer, which was rescinded, it appears, only after the background check was conducted. So they then hire somebody who's younger with less experience. And so he's claiming, look, agency number one, and I'm going to say this slowly, he says that agency number two, his prospective employer, retaliated against him as a result of actions and of him being a whistleblower while employed by agency number one. So he sues agency number two, saying you're retaliating against me as a whistleblower when I was at agency number one. And so I thought, my first thought of that as I looked at these was, no way, that Title VII doesn't protect you, an employee, a non-employee at a separate agency who's not related to or part of, or right, the agency at which you engage as a whistleblower. So here was my question. So I wanted to look at that question, and I have an answer. I have a good answer. So my question, if I was moving to dismiss this case, would be to say, look, if his first agency retaliated against him, that would be one thing, because Title VII would protect, if you're a whistleblower at your agency, it would protect you from retaliation by that agency. My question is, okay, assume for the moment that agency number two, his prospective employer, really did retaliate against him, saying, oh, we don't want those types of people here, which I think is what he's alleging, right? He'll start whistleblowing against us on things we're doing. So we're going to not hire him as a result. And I found a case from 2013 in the it's in the federal courts. It's in Florida, a case called Underwood versus Department of Financial Services. Exactly these facts. Worse, his facts are not as good as these, but basically here it was a person in the Underwood case. I won't get too much in, but he's in agency one. And his wife, in this case, testified in agency two, and he claims that, and they fired his, and anyway, he gets fired, but he basically claims what happened at that other agency with my wife whistleblowing, which was attributed to me. He said, I was retaliated against at that other agency. And the court looks at the exact question I posed, whether, again, if you're in agency number one where you whistleblow and now you're in agency number two, can agency two violate your rights under Title VII by retaliating against you for something you did at agency one? And the short answer is no. That Title VII was not intended to go there. Curt, I'll send you this case. It's really interesting, very confusing. It took me a long time writing notes and parsing it out. But nonetheless, they said that there's I'm trying to find some good language. Well, in any event, they said Title VII never meant to go that far. It's not protecting you against some other employer. It's only protecting you against that employer. Now, in that Florida case, they did say, well, listen, we're still going to look, are the employers related? Do they have their same hiring group? So for example, if you're in a county and there's a Department of Public Works and a fire department, well, that's different agencies, but same employer, that would still, Title VII would still apply. But where you have two separate employers, not funded by the same entity, under two totally separate employment and hiring and firing structures, they're unrelated entities, Title VII doesn't protect you against that. So I thought it was interesting, but I don't know if they're watching or will watch, but we get a lot of your viewers watching, or a lot of your, people involved seem to watch this and find out. If that California firefighter is watching, I think he's got a tough road to hoe on this case. Yeah,
it's a tough fact pattern, and again, maybe it is under California law. So there may be some language differences between Title VII and state law, but the principles, very often the legal principles on the federal side apply on the state side as well. So that'll be an interesting one.
I think that's it, other than Beyond the Blog.
Yeah, that's it. Let's just take a quick look at Beyond the Blog and see if there's anything of interest. Oh, the Denver firefighter and the stuffed rat. I don't know if you saw that one.
I did not.
And I may blog about that one. That's an interesting one. We had a Denver firefighter. Starts with a captain who's being disciplined for something that happened, and so you have a firefighter witness who's going to testify, apparently, about what exactly happened. There was a captain and a lieutenant had a little beef or something, and so there's a firefighter that was going to testify as a witness in the discipline against the captain. And the next thing that happens is someone puts a stuffed rat next to the bunk of the witness. And so they start an investigation, and it's witness intimidation. In fact, they could be criminal. In fact,
they did felony in a lot of states.
And a lot of times firefighter, our peer pressure and how things can happen, but it's witness intimidation, especially a rat. Right. You're ratting out someone and so on. So they launch an investigation, and fairly quickly, I guess, one of the firefighters owns it. He says, "Yeah, I did it, but it was just a joke. I didn't mean to witness intimidate." And what else is he going to say? And so he ends up getting, I'm looking at it right here, 408 hours, which I think is 17 24-hour shifts, if my math is correct. But that's I think the article that I have linked to it says it's 51 days. If you run out the schedule, it's he's going to be suspended without pay for almost 2 months. And it was interesting, and one of the things I found interesting in it has to do with to me, it's fairly new. Now, maybe it's been around for a long time, but it has to do with imposing a penalty, but holding it in abeyance. And as long as I've been around, fire service as well as the practice of law, we've had this thing called the last chance agreement. And a last chance agreement is basically, we've got you over a barrel. We could fire you, but we're not going to. But for the next year or the next period of time, you're going to be on probation. If you do anything wrong, you're gone. Okay. Basically, we're putting you back on probation. And this concept of holding charges in abeyance is similar, but it's very different. And there's a lot of case law on last chance agreements. And I know in where we're from, you can't have a last chance agreement for 10 years or 15 years. It's got to be limited. And we recommend here no longer than a year. There are places in the country that'll go to 5-7 years. Okay. When this holding in abeyance is a little bit different because and essentially what they did in this case in Denver was they terminated the firefighter. They said, we're going to hold the termination in abeyance. And I think it's going to be 5 years. But you can't violate any more rules. But the nice thing about holding things in abeyance, as opposed to a last chance agreement, is you have a lot more flexibility in that all the case law on last chance agreements don't necessarily apply. Now, you could get in a court or an attorney that's going to argue that it's the same thing, it's just a different name. But you can hold in abeyance for other types of things short of termination. You could say, okay, I'm going to give you 48 hours off without pay, but we're going to hold it in abeyance for a year. So as long as you don't get into trouble again, you're not going to have to go 2 days without pay, 48 hours without pay. So it has some advantages. So interesting. I think if I depending on what's going on in the fire law news tonight, when I sit down and blog, I may go back and cover this one. But it's an interesting case, and I think it's worth folks taking a look at. And they actually have a copy of the discipline report, the determination, the findings of the hearing officer, and the hearing officer pretty much says, yeah, we're not buying your argument that this was not intended to send a message to this employee. So interesting fact pattern there. And let me just go back here. New York City has had a number of cases. Their pension fund, well, the police and fire pension fund, there's several different funds, but they're suing Activision now on some financial disclosures and so on. So civil suit down in Florida over the Reedy Creek dissolution and the burden that that's going to create. For those of you who haven't been following it, the legislature is sort of withdrawing because of Disney started getting involved in some political activities, which they're a nonprofit. They really shouldn't be, especially things that don't relate to them. They started sticking their nose in there, and the legislature and the governor said, "All right, you want to play like you're a private industry actor. You're not a nonprofit. Well, And so now they're sort of in deep. They're going to be withdrawing their ability to have their own municipality. And now the residents are suing the state, challenging that act because it's going to burden police and fire and a number of other services that Reedy Creek had been providing. So quite a mess down there. Quite a mess. Volunteer arson case, another one of those. And you know what? I could do a blog just on volunteer arson, volunteer theft cases. Yeah. It's just, we got to kind of, realize that there's more going on, but there's a ton of those cases. Off-duty Buffalo firefighter having an issue there in a shooting. And again, another officer, captain in a volunteer fire department arrested for embezzlement. So that is it for Beyond the Blog. And Brad, I know you're heading out of town.
I am vacation finally. So I've been working for a long time to be able to get to a point in my work caseload where I can actually take a vacation. I'm sure that'll last 2 days, but nonetheless, so I may not see you next Monday, but you may have a guest appearance. I don't think you're going to want me go after a week.
Maybe we'll have Nicole. Maybe we'll have Nicole on.
Nicole,
she'll be sober. So,
right.
All right, folks. Well, that's going to